Character and issue can use specific instances of conduct when character or trait is an essential element of a charge, claim, or defense under substantive law. Examples: defamation, entrapment. Character and issue: what lawyers say when brought in under 404A1, but 405 is meant to open the door for rebuttal. Character as an element of a charge, claim, or defense. Greta is charged with shoplifting from Bloomingdale's. Helen's security guard stopped her after she was in at the dressing room and was leaving the store. Testimony that Greta stole other items in recent weeks on videotapes violates prohibition in 404A, and none of the exceptions apply. Character is not an issue. Prosecutor needs to show Greta stole on that particular occasion. If used for non-propensity, then would have 404(3) problems. Testimony that Greta had reputation among security guards as a shoplifter, inadmissible, no exceptions apply. Greta had offered evidence, character, yet evidence of prior convictions of shoplifting, none of the exceptions apply. Only have to prove the element or current crime, 404B exceptions. Prior acts is proof of motive, intent, plan, or related points. 404B, other crimes, wrongs, or acts may be other inferences that can be drawn from the character evidence. If you can make an argument for something other than action of conformity with propensity, then 404A does not apply. Motive, opportunity, intent, preparation, plan, knowledge, identity, not exclusive list. The only limit is the requirement of materiality. Cannot show propensity of a person to perform specific acts. Prior acts to show motives, prior acts to show modus operandi, show identity, prior acts to show character, or show knowledge. Proving intent. Kicks us back, 404B kicks us back to 404(1), 402, 402, 403. Factors prosecutions need or degree of probative value. What is the nature of the prior misdeed? 404B, prosecution must give notice to defense of what the evidence will be offering. Identity, modus operandi, distinct pattern, method of operation of the crime. Plan or design, other purposes, proving the prior act. Alrighty. Uh, 406, habit, routine, practice. We have three elements. Specificity, regularity, and subconsciousness. So specific, regular, subconscious. Specific, regular, subconscious for habit, routine, or practice. Rule 406, evidence of the habit of a person or the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, is relevant to prove the conduct of the person or organization on a particular occasion was in conformity with the habit of routine and practice. Evidence of the organization routine will be more likely to be admitted than individual habits. Talking about guidelines, supervision of employees, manuals, and authority. Habit is a regular response to a repeated specific situation, more specific than character. Character tends to have moral overtones, some kind of, while habit does not. One of the only rules says that evidence is inadmissible. Picking your mail at a certain time, that is habit. Being punctual is a character trait. The advisory comment note states that character is generalized description of one's disposition or of one's disposition in respect to general traits such as honesty, temperance, or peacefulness. Good and careful driving evidence is too general to be habit. It is character trait of carefulness. If someone is driving a specific speed limit when they're on a specific highway, then this may be more specific for habit evidence. Never receiving tickets would be character. It's kind of a spectrum. Evidence of an organization's routine will more likely be admitted than an individual habits. Talking about guidelines, manuals, and authority. Remedial measures, 407, subsequent remedial measures, when after an injury, harm allegedly caused by an event, measures are taken that if previously would have made the injury harmless, less likely to occur. Evidence of subsequent measures is not admissible to prove negligence, culpable conduct. A defect in product design or a need for warning instruction. Measures include hiring practices, retraining workers, firing workers. Exception: this rule does not require evidence subsequent remedial officer offered for another purpose, such as proving ownership, control, feasibility, precautionary measures, if controverted, or impeachment. Or for impeachment. Examples: the Ford Pinto, doctors, settlement negotiations, civil settlements. Also, as a side note, questions that I asked her were doctrine of chances 404B, kind of generally mentioned. It's the wives of the man who had died in the husband's bath. The first wife dies drowning in a bath, the second wife dies drowning in a bath, and the third wife dies drowning in a bath. Doctrine of chances, what are the chances of this likelihood happening? Oh, excuse me, I was about to sneeze. Rule 404A, compromise and offers to compromise. Evidence: furnishing or offering or promising to furnish, or acceptance or offering to promise, saying to accept a valuable consideration, compromising or attempting to compromise a claim which was disputed as to either validity or amount is not admissible to prove liability for or invalidity of the claim in its amount. Rationale: the very little probative public policy encourages settlements. Also, a note on settlements: civil settlements are not usually admissible in the criminal case unless you settle with a public entity. The elements are: there was once a dispute, and 2, conjunctively, an offer to settle the dispute. Rule 409, payment of medical expenses. Evidence of furnishing or of offering or promising to pay medical, hospital, or similar expenses occasioned by an injury is not admissible to prove liability for the injury. No exclusion for surrounding statements to settle at the time that you agreed to pay the medical bills. Criminal cases: 410, inadmissibility of pleas, plea discussions, and related statements. An offer to plead guilty is not admissible to show guilt. A plea of guilty which was later withdrawn. A plea of no contendere, any statement made in the course of the proceeding under Federal Rule of Criminal Procedure 11. If during plea negotiations he says on the stand during the plea, can you impeach him with it? Rule 410, last paragraph. I can, in subsequent procedure for perjury, not in criminal trial, assuming it was under oath. This can be done to encourage plea negotiations, have free discussion. Only bar evidence by the defendant in the course of the plea discussion with an attorney, prosecuting with the attorney. Rule 411, liability insurance. Evidence that a person was or was not insured against liability is not admissible on the issue whether the person acted negligently or otherwise wrongfully. This rule does not require exclusion of evidence insurance against liability when offered for another purpose, such as proof of agency, ownership, control, or bias. Prejudice: a witness often will come in during the trial, is mostly offered for other reasons. Alrighty, now going to competency of a witness. A lot of the old common law rules have been kind of generally gone away, and then 601, Texas rule, statute, lawyers as witnesses, jurors as witnesses, judges as witnesses. You need personal knowledge, mode and order of interrogation, direct examination, cross-examination must not be within the scope of direct examination, exclusion of a witness, There are 4 categories of witnesses that can't be excluded: natural persons, representatives of the party, essential presentation, persons who are essential to the presentation of the case, person who are authorized by statute to be present. Impeachment of a witness. There are 5 ways to impeach a witness: showing witness has a bias or motivation that might cause them to fabricate or shade the truth of the attacks, showing defect in perception of memory, prior inconsistent statement, contradictory witness, untruthful witness, and yes.